How have insanity defense laws evolved in US states? Imagine facing a criminal trial where your mental state at the time of the crime could change everything. The insanity defense has a long history of shifting rules and debates. Originally, most states followed the Monodon Rule, set in 1843, which asked if the defendant understood what they were doing or knew it was wrong. This rule focused mainly on the defendant's cognitive awareness. Over time, some states added considerations for whether the person could control their actions, including the volitional aspect. A major change happened after the 1981 trial of John Hinckley Jr. He was found not guilty by reason of insanity after attempting to shoot President Ronald Reagan. The public reacted strongly against this verdict, leading to reforms. In 1984, the federal government passed the Insanity Defense Reform Act. This law made it harder to claim insanity by requiring defendants to prove they did not understand or appreciate the wrongfulness of their acts with clear and convincing evidence. It also shifted the burden of proof onto the defendant and limited expert testimony on legal questions. Many states followed the federal lead, tightening their standards for insanity. Some states kept the traditional tests but made them more restrictive. Others, like Idaho, Kansas, Montana, and Utah, decided to eliminate the insanity defense altogether as an affirmative defense. However, even in these states, defendants can sometimes argue mental incapacity to show they lacked intent. In most places, the burden of proving insanity rests with the defendant, who must show it by a preponderance of evidence or clear and convincing evidence, depending on the state. If found not guilty by reason of insanity, the person is usually committed to a psychiatric facility instead of prison. But courts have limited indefinite confinement, especially if the mental illness improves. The Supreme Court has played a role in shaping these laws. In 2020, the case Collar v. Kansas confirmed that states can abolish the traditional insanity defense if they want. The court upheld the idea that states have the right to define or eliminate the defense based on their own standards. For criminal defense attorneys, understanding these evolving laws is key. They need to know the specific rules in their state, including what evidence is needed and who bears the burden. Expert psychiatric evaluations are often crucial to support an insanity claim. Overall, the trend has been toward stricter standards, making it more difficult to succeed with an insanity defense. Still, it remains an important strategy when mental illness significantly affects a person's ability to be responsible for their actions.